It's a real sincere pleasure to welcome everyone tonight and to make a special welcome to His Excellency Judge Patrick Robinson. It's a real treat to have him back to King's. King's has a long relationship with the International Court of Justice. And I'm going to say just a word about it because one characteristic of our relationship with that court is the people who have been there have had varied, rich lives. And since that's what we'll reach toward the end, we may not have time to talk about that. But toward the end of the 1800s, there was a dream, a belief that an international court, rather than international arbitration, might lead to the avoidance of war. And progressively, Permanent Court of Arbitration, the Permanent Court of International Justice, and after World War II, the International Court of Justice. And we've had a number of graduates closely affiliated with that court. In fact, in 1893, Muhammad Zafrullah Khan was born. So 6 years old in 1899 at the Peace Conference of The Hague. But he got his LLB from King's in 1914. He returned to the court. Well, he was first foreign minister of Pakistan. He was on the court from 1954 to 1961. He left to be the representative to the General Assembly for Pakistan, becoming the first Asian president of the General Assembly of the United Nations, and returned to the court in 1964, where he stayed until 1973, becoming president. Now, a very interesting twist, since I've been here, I got an email from a historian in Israel asking me if I could produce the records on Sefton Rosen, who graduated from King's in 1938. Well, Sefton, it turned out, changed his name to Shabtai Rosen along with Israel. And Shabtai Rosen is probably the authority in the court. He's now passed, but he would have been a main advisor in all the cases that Khan probably heard at that time. Most recently, Abdul Karoma from Sierra Leone was a judge with the court from 1994 to 2012. And just as Judge Karoma was returning to his country after 2 terms, we found that Judge Patrick Robinson from Jamaica was joining. And it prompted us to invite him tonight to have this conversation. But as I saw in 2011, when I first met Judge Robinson in Washington, D.C., an organization I was with was bestowing an honor on him at that time. He's had a really varied career. So we're going to start. The plan tonight is we're going to go through that career in sort of stages, and then at various points I'll try to invite questions so that we can sort of talk about that time in his life. But welcome, Patrick. I'm going to call you that tonight so we can keep it informal. And perhaps we could just start with your time at King's, and then we'll back into Jamaica. But what was your memory of King's?
Thank you very much, David. First, I'd like to say how wonderful it is to be back at King's. It's actually my first visit here after leaving in 1972. And I feel quite ashamed about that.
We're ashamed.
Yes. And the place is not very recognizable. And I think it is very appropriate for me to congratulate the Dean and the college as a whole for the wonderful building which you now have. I think it must be very inspiring for the Dean and his faculty and the students to work in such wonderful surroundings. I came here in 1971. In the previous year, 1970, I had been a UN UNITAR fellow in The Hague, as a matter of fact. And I spent 6 weeks at the Hague Academy, And I had an outstanding tutor in Sir Francis Vallet.
Ah,
And
a member of this faculty at
yes.
that time.
He was then dean of the faculty here. And he encouraged me to come to King's. And so I was here in 1971 on the basis of a Commonwealth scholarship. And Sir Francis it is who really brought me here, and I had a wonderful experience with him, because studying with Sir Francis was literally like getting it from the horse's mouth, because he had been one of the last special rapporteurs to the UN conference on the law of treaties that produced the 1969 Vienna Convention on the law of treaties.
Yeah, that's great. So let's back into Jamaica. And growing up in Jamaica, what was leading you to be interested in UNITAR and the Hague Academy and leaving Jamaica?
Well, my schooling in Jamaica was very, very typical. I went to an elementary school. In fact, my father was the headmaster of the school. My father was a teacher. And from that school, I went to Jamaica College, which was a boarding school. I had not even turned 10 when I went to Jamaica College. And the Jamaica College as a boarding school is modeled off a British grammar school. And I spent 7.5 years there. And after that, I went to the University College of the West Indies. Now, the University College had been established in 1948 as a College of London. And I did English, Latin, and economics. In those days, people did do Latin, believe it or not. And it turned out Latin was actually my best subject at school. But that experience with the University College of the West Indies and the connection with London University actually turned out to be quite beneficial, because when I applied to Middle Temple to read for the bar, I was quite distressed to see that the fee was £180. Now, I had been teaching for 2 years at a secondary school and had planned to save £20 a month, but I never quite made it. So when I saw that, I was depressed because I did not have £180 saved. And then there was an asterisk in the letter from Middle Temple. When I looked at the footnote, it said, if you are a graduate of any of the following universities, you may apply for an exemption of £100. And one of the universities was the University of London. So I sent in my university degree, and I only paid £80. So that's how I went to Middle Temple. But so I became a barrister at Middle Temple in 1968, returned to Jamaica, and my first real job was at the Director of Public Prosecution's office, where I prosecuted a whole range of crimes, murder, rape, fraud, you name it, for about 3 years. And
So let's stay with that. And I'd like to, I think one thing very interesting, people go into these international careers, but the strong dimension of experiencing law within your country and criminal matters.
Yes.
I don't know if you did family law, but you were in public prosecution. So what do you carry away from that period?
Well, let me tell you frankly, anything good that I achieve in law, I attribute to the 3 years I spent, those very important foundational years at the Director of Public Prosecution's office, because I had tremendous responsibility. I would prosecute a case of murder at age 26, a man charged with stabbing his wife 12 times before his 6-year-old son. And on the other side is the most distinguished Queen's Counsel in Jamaica with 2 other lawyers, and I am there alone. I have to counter arguments relating to diminished responsibility, automatism, and you name it. That case became quite a landmark case in terms of the law on self-defense and the law on diminished responsibility. The man was ultimately convicted of manslaughter on the basis of diminished responsibility. But in the middle of the case, what was interesting was that counsel for the defense started to run automatism. Now, automatism would mean that he could walk free. So I had to cross-examine the doctor whom they had called quite thoroughly to rebut automatism. We had another big problem in the case. I called the 6-year-old boy. He was the witness. He saw it. He's examined on the voir dire by the judge. It is the judge's responsibility to determine whether he is fit, whether he understands the nature and duty of speaking the truth. The judge makes the determination. I start to examine him. And when I reach the part in the evidence, he says, "What did you see Daddy do?" Counsel for the defense jumps up. This is preposterous. This boy can't give that evidence. And the judge, who had ruled himself that he could give the evidence, then sided with counsel for the defense and said, "Mr. Robinson, how can you have a 6-year-old boy giving the evidence?" I said, "My lord, you had made the determination as a matter of law that he was fit and proper." So I lost that witness. I lost him completely. But the case ended in manslaughter, and I think that was a fair verdict, all things considered. I had one other very important experience in terms of my international law at the DPP's office. Jamaica's first extradition case was in 1971, and I was asked to do it. The DPP asked me to do it. It was a case involving a Jamaican, allegedly, who had committed murder in the USA, had fled to Jamaica, and I was introduced now to the law of treaties. Because what is the treaty governing the relationship between independent Jamaica and the United States to allow for this? It is a 1931 treaty between the United Kingdom and the USA, which had been applied to Jamaica as a colony. Defense counsel never took the point about the applicability of the treaty. But 2 or 3 years later, they saw their mistake, and they did take the point. Now, by that time, I was ready for them. See, I was a government, remember, I was a government lawyer, you know? And I was able to profit from my experience in the 6th Committee. I see Sir Franklin Berman here. Thanks so much, Frank, for coming. You know, we were in the 6th Committee together, and I had just been exposed to succession of states in relation to treaties. I had participated actively in the debate in the 6th Committee, and I knew the answer to the point being taken that the treaty was not applicable. But I had to spend hours in court and a lot of research to convince the court that the treaty was applicable on the basis of the mutual agreement, not between the UK and the USA, but between independent Jamaica itself and the United States, who had made the application, and Jamaica had responded. So on that basis, we were able to establish the applicability of the 1931 treaty. So I was introduced from very early in my career to the law of treaties. So when I met Sir Francis Vallet and was inspired by him, he encouraged me to come to King's, and one of the subjects that I did was the law of treaties, and it has remained my favorite subject international law.
So let me drop an asterisk, as Middle Temple did for you. So Sixth Committee refers to the Sixth Committee of the General Assembly, which is the legal committee, and dealing with many such issues. Before we leave, you made a very powerful statement that you look back at that time as so foundational. And in conversations, I think we all experience this, people look back to a certain point as so pivotal. Sometimes it's a certain lecture, a certain professor you had, sometimes it's work. But what is this teaching you? I heard confidence, you're facing this QC,
Yes.
but what,
Yeah, I can tell you exactly what it taught me. Confidence, yes, because you can't appear in a criminal court and not be confident. If you're up against senior counsel, you have to be confident. You have to do your research. And so in the representational work that I did for Jamaica, when I moved to the Attorney General's Department, I benefited from that. I knew how to make my points, when to make them, what to stress. You know? And representational work is, of course, not as adversarial as working in the criminal court. You know, we have the adversarial system, and of course, some lawyers take it literally. They see you as their adversary. But I would certainly strongly encourage anybody who is thinking of a career in international law to base it in practice.
yeah.
You can only profit from the practice that you have had in court.
So you're with the department, you're with the Jamaican government, that's 1972 to 1998 roughly. But one thing I think you could hear there, you're simultaneously representing Jamaica in the Sixth Committee or at various conferences. And one thing, so I find surprising at times coming from a state that would have a governmental ministry with a lot of lawyers, subdivided in many ways. How would you describe Jamaica? Number of lawyers, how many different portfolios do you have? How are you working together? What does that mean for your experience?
Well, let me say that I was very fortunate. I had the best of both worlds because I was doing representational work for Jamaica in international law, negotiating treaties. I was also representing the Attorney General's Department in civil constitutional cases. So I was doing two kinds of work. And that's what I wanted to do. Now, in Jamaica, as in many other Commonwealth countries, it is the Attorney General who is the legal advisor to government. It's not the Minister of Foreign Affairs, not the Ministry of Foreign Affairs. So the Ministry of Foreign Affairs had to procure its legal advice from the Attorney General's Department. And the Attorney General's Department jealously guarded that right and fought against the ministry establishing its own legal department. And I was involved in that fight. I'm not very proud of it, no, but that has changed, and it was right that it should change. You know? But I still believe that the lawyers who represent the government, whether the Ministry of Foreign Affairs, any other ministry, would benefit from experience in court. At that time, when I started, which was 1968, remember that was just 6 years after Jamaica became independent. in 1962. So we didn't have many people doing international law. In fact, I could only think of two. Ken Rattray, who was the Solicitor General, as very well known and distinguished, and perhaps one or two other persons. So it meant that you were called upon to do a variety of international law matters, whether it's in treaties, it could be privileges and immunities, it could be law of the sea, it could be air law, it could be anything. So one of the main differences between an international lawyer, somebody working in international law at that time, for a developing country, and the same kind of person working for a developed country is that the international lawyer from the developing country would be a generalist, because you have to be, because you have to cover so many different areas. And I always give this experience as an example, because you go to a conference and you're a delegation of one, or at the most two. The developed country will have a delegation of 5, 6, or 8 persons. A technical point comes up, and the leader of the delegation from the developed country doesn't have the answer to offer the clarification. But the 6th or 7th person in the delegation is the specialist in the area. And that person will send a note up to the leader of the delegation who offers the explanation. Now, when you're there from the developing country, you have nobody to turn to. So what it means is that you would have had to do twice as much preparation for those negotiations as the lawyer from the developed country. And quite often, I would have people say to me, when they would see me at different negotiations, why are you here? How do you cover so many areas? But that was my job, and I never minded. I believe that I actually benefited from the multifaceted character of the work.
Yeah. Well, in 1998, Judge Robinson is 1988. Let me back up. Is shifting to the Inter-American Commission on Human Rights. I can't, moving from being national representative to having a position on a commission. Now, just as we make that move, I'm wondering if anyone has questions about this early phase in life within being a lawyer within Jamaica. Then let's just head on. To me, that would have been a very dramatic shift. And so I guess, as you talked about cases you had, perhaps there's a particular effort you made on the Inter-American Commission on Human Rights. This commission covers all of the Americas. One question I would have is, you're moving to a regional system in which there's quite a few regions within the region. And if you take Latin American and the Caribbean and then North America, with their own images of these standards. On the one hand, we have universality within a region. On the other hand, it's not, on the other hand, not easy to apply it within those. Or perhaps your experience is different.
Yes, actually the movement was not so dramatic. Because remember that at the Attorney General's Department, I'm advising on treaties. Mm-hmm. And human rights treaties too. Jamaica was party to the International Covenant of on Civil and Political Rights. So I had to advise on that. It's more or less the same kind of rights in the American Convention on Human Rights. So there was that familiarity, so it wasn't a very big jump for me. I think the big jump was now working with, probably for the first time, lawyers from the civil law jurisdiction. Because as you said, Latin America and the Caribbean as an area has divisions. The Latins are civil law countries, the Caribbean generally common law countries. The Latins speak Spanish, except for Brazil, where Portuguese is spoken. The Caribbean speak English. I found that that was one of the challenges. How to ensure that you made a contribution that contributed to a human rights system for the Americas that was really representative of all the systems. And it was perfectly possible. And we did, and we did. But there are important differences between the two systems. That I remember one particular, I think it was a treaty we were doing, and I was talking about a judge doing this, a judge doing that, and I said, what are you talking about? A judge in our system can't do those things, But their system is inquisitorial, And so you have to learn to reconcile. So that was probably my first effort at reconciling foundational systems that I brought to the Inter-American Commission to ensure that I was able to contribute to the global system that it covered. Now, when I went to the Commission in '98, January, it was at a very critically important time in the history of that body. Many Latin American countries were just transitioning or in the process of transitioning from military to democratic governance. So I got the end of that, and to participate in that was just wonderful. The Inter-American Court had, just before I arrived, put out a very important decision, which I think changed international human rights law, the Velázquez-Rodriguez case, which emphasized the duty of the state to prosecute. Is that in Latin America at the time, you had this phenomenon of disappeared persons. And persons were disappeared. became a word, whether it was Argentina or Honduras. And Velázquez-Rodriguez was a seminal case in emphasizing that the state had a duty to investigate and prosecute these cases. I would actually say that of all the different areas in which I've worked, the 2 terms that I spent on the commission, I would consider the most important facet of my career. I don't think that a lawyer can be asked to do anything that is more important than to defend human rights, fundamental human rights. Of course, my own background would explain the strong interest I have in fundamental human rights. And when I became president of the commission in 1991, I had to go to the Gambia, to Banjul, where the African Court of Human and People's Rights was located. And it was a very historic and emotional moment for me because, as you know, Jamaicans came from West Africa as enslaved persons. And so it meant a lot to me. But the history of your country is bound to influence the perspective that you have on law, on international law. And so one of my main areas of concern has always been the protection of fundamental human rights. And the Inter-American Commission gave me that opportunity to express that interest.
Did you have a particular portfolio within the commission? I remember one fellow I knew, on the commission, his task was to look at prisons within the Americas.
Yes, yes. I was the special rapporteur for an instrument on indigenous peoples. I worked hard at it, and I did produce a draft on indigenous peoples. Of course, I would have gone there with a great familiarity with enslavement, but the rights of indigenous peoples was something that was new to me. And so it was very important for me to have been asked to be the special rapporteur on the rights of indigenous peoples, yes. Because indigenous peoples faced severe hardships. Well, remember that all of America, Canada, and Latin America had indigenous peoples. Where are they now? In the Caribbean.
Jamaica.
Yes, in Jamaica, you had the Taínos. Taínos. In fact, we called them Arawaks until we were educated some 20 years ago. And we now know that they were Taínos. But when the British came, when the Spanish came to Jamaica first, and between the diseases and, of course, violence, they were decimated. And that was typical. That happened throughout the Caribbean. In North America, pretty much the same thing. So that there's really a great need for work to be done on the rights of indigenous peoples.
So just before we ask for questions, I just want to ask, the reason I would have said a shift, and I find it positive that you didn't feel there was a dramatic shift, is the idea of moving from being a lawyer for a government, which ordinarily be the one responding to a complaint concerning human rights, to being someone who is out trying to improve human rights, mediate the question between the people and their various states, various governments. But that, for you, was not a shift.
No, it wasn't. And that is really due to my own personality. And that is actually due to the way I was brought up. Because I was brought up by a father and a mother who stressed fairness as the hallmark of the good person. And so even when I prosecuted cases, I have to tell you, I always had a sympathy for the accused persons. Always had a sympathy for the accused persons. And I'll tell you one story that indicates this. At the Attorney General's Department, where I did a lot of extradition cases, I had an extradition case, again a request from the United States. Now this fugitive was in Jamaica. The USA, they got in touch with our police and they arrested the man without going through the procedures under the Extradition Act. So he applied for habeas corpus. Well, I went to court and I supported the application. The DPP opposed it and the judge saw red. He was angry with me. He said I was like Humpty Dumpty I made words mean what I wanted them to mean. He was just expressing his anger in his judgment. So he rejected the application for habeas. And I advised the lawyers for the man that in habeas corpus, you can go from judge to judge. It is a peculiarity in the law. Frank might know about that. So they went to another judge. This time now, we had 3 judges. The first one was before the single judge who lambasted me. This time now I'm before 3 judges. And again, I support the application with arguments that you cannot arrest a man in Jamaica on the basis of an offense he committed in a foreign country unless it is pursuant to the Extradition Act. You cannot do it under the common law. And we had cases, which there was one particular case that was cited, but it was very dubious. And we argued that case for about 6 weeks. The DPP opposing the application and the Attorney General's department supporting it. Eventually the judges agreed with the position that I had taken. And so the man was free. But the point was made that they could then apply again and go through the proper channels. So that it wasn't difficult at all for me going to the Inter-American Commission to take a proactive view in favor of human rights, because my own disposition, I would have had a predisposition to do that in any event. And even at the Attorney General's department, when a claim was made against the government, I always felt sympathy for the person making the claim. Of course, eventually I tried to decide the case on the facts.
Right, of course.
Rather than on the basis of the sympathetic feeling.
So Judge Robinson became chairman of that commission in 1991. Are there questions concerning this period? Yes, Professor Tsoulas.
I want to ask you 2 questions. You made the dramatic statement that there's nothing more important that a lawyer could be asked to do than defend human rights. And I think you qualified that by saying fundamental human rights. How would you pick out what the fundamental human rights are?
Well, I didn't
And the
want...
other question was just, you mentioned that you were a generalist lawyer, and you had this general competence. A lot of people now talk about the fragmentation of international law. Do you think that phenomenon makes it almost impossible now for people to aspire to that generality of competence?
Well, as for the first question, I didn't really intend to emphasize a difference between human rights and fundamental human rights, because how you make that distinction, I think we could probably spend the entire evening discussing that. But a lawyer's work must be concerned with getting it right, you know, in whatever area of law that you work in. Law is concerned with getting it right for your client. You know? And the most important thing to get right, I think, is those rights which most people agree are fundamental to the human being by virtue of his or her inherent dignity. Because inherent dignity, I would like to see as the basis. I won't say fundamental basis, lest you ask me another question. But as the basis for human rights. And I can't apologize for the interest that I have in it because of the history of my own country, going through enslavement and colonialism, and now no independence. Now the next question about the fragmentation of international law, I've always felt that it's a little overrated. I think it's overdone, because I believe there are many aspects of international law which can lead to an integration of the different areas. And as for whether persons now can be generalists, probably not in the way that I was able to work as a generalist anymore, because there are so many specialized areas now in international law. And I saw that one of the questions that I would be asked had to do with giving advice to students. And I wanted to stress just the variety of subjects and the very wide areas that one can work in international law. And in a developing country, it is still the position, although probably less so in Jamaica now than in my time, that when you start out in international law, you will start out doing everything for the reasons of lack of manpower. No, as I said, and that is in contrast with the position in a developed country, because in Jamaica and in most developing countries, the traditional areas where you can work in international law would be governmental. Mm-hmm. The Attorney General's Department in countries that have that, or the Ministry of Foreign Affairs, or some other ministries too will do work which relates to international law, environment, and other areas. But in a developed country, you have other opportunities because you have important work going on in private practice. You have firms devoted to the practice of international law. So the opportunities are much wider. And of course, whether you're from a developed or developing country, there's always the United Nations and its myriad of agencies and bodies. It's not easy to get in though. I mean, when I went to the tribunal first, I was shocked to find you could find over 1,000 applications for a single post. So one has to be very well qualified to work in those international bodies. There was somebody on this side who wanted to ask.
Question here, yes, thank you.
Carol Thompson, President of the Indigenous Students Association. But unfortunately, just answered the question. I was going to ask you if you felt that you had a strong predisposition for fairness, for human rights, and representing people. I was going to ask, why did you, after leaving England, just go and work for the government? But you just explained that there weren't that many opportunities. So.
Yes, because and as I said, it didn't really blunt, working for the government didn't blunt my predisposition to fairness, because as a prosecutor, but I'm proud to say that I had a reputation of being fair. So you mustn't believe that because you're a prosecutor, you are unfair. That's not right. not right at all. And fairness has been the driving force in everything that I've done, everything in law. I believe you probably will ask me about the Milosevic case,
Well, we should move. I mean, there's a dramatic shift from the Inter-American Commission. Well, in between, there's a number of things. The International Law Commission.
Yes.
Working in Haiti.
Yes. Yes.
So there's a number of matters that happen in between. But we should go to, in 1998, you moved to the International Criminal Tribunal for the former Yugoslavia. And so here we have a special war. I think for those of you who are not familiar with this history, Nuremberg, for people in the 80s, in the 1980s, Nuremberg would have seemed like that's not going to come around again, that there would be such a war crimes trial. But here we see the return with the Criminal Tribunal for the former Yugoslavia, where you served from 98 to 2014, and are president of that tribunal from 2008 to 2011. Perhaps you were just referring to one of the more notable trials that you were involved with, and that was Milosevic.
Yes, but well, before I speak about that trial, and of course I will only do so in general terms. Going to the tribunal was, again, an easy transition for me. Because remember, I had started out as a prosecutor. And then I had spent 20 odd, almost 30 years in the Attorney General's Department, advising on international law, representing Jamaica in the 6th Legal Committee of the General Assembly. I had also been a member of the International Law Commission, which, as you know, is concerned with the codification and progressive development of international law. So why was it an easy transition for me? It's that the International Criminal Tribunal for Yugoslavia was charged to prosecute the most serious crimes that had been committed in the former Yugoslavia. And these were breaches of international humanitarian law. So it's a criminal court. So it calls first for experience as a lawyer in court. It calls for court experience, which I had. So that was a plus for me. And then the area of law that was relevant is international humanitarian law. Yeah? I had done armed conflict at King's as one of my subjects. And at the International Law Commission, I was a member of the working group that was tasked with drafting the first statute of an international criminal court. You know? So I went there with experience in the two areas that were most relevant to the work of the tribunal. Practical background in criminal law, knowing how to run a trial, although I had not been a judge in Jamaica, but I had, of course, been in many, many cases. So becoming a judge was not new to me. In any event, the system that we have in Jamaica and most of the Commonwealth is that you are not trained to become a judge, you know, as you are in many civil law countries. And the training takes a long time in civil law countries, probably 5, 6, 7 years in some countries. You are picked to become a judge after years of practice. You know, that's generally how it is done. So that becoming a judge there was not difficult for me on the basis of the experience that I had. You know. Now, work at the tribunal was, at first, I found very traumatic, listening to these horrific tales of violence, horrific tales. After a while, you could become numb because you heard them so many times. But there was one case in which I was actually moved to tears, you know? And I had to do my best to ensure that this unjudicial conduct was not witnessed by anybody. It was evidence from a young man who was no more than 18 or 19 years old. You know? And he had lost 19 members of his family, his mother, his father, his brothers, his sisters, his grandparents on both sides, uncles and aunts, a total of 19. And that just did it in for me. I just couldn't imagine how he could have endured a loss of that kind. You know? And I put myself in his position. I said, how would I react? You know? But of course, you have to steel yourself as a judge and make sure that you examine the evidence dispassionately. But before speaking about the Milosevic trial, I'll tell you of...
Can I just ask you one question
Yes.
on that for a second? So there's an interview of Antonio Cassese
Yes.
in the New Yorker that's rather famous. It's a quite powerful piece. And the question is put to Antonio Cassese, how do you deal with that? How do you heal yourself? Go back? Do you have some routine you use? His statement was art. His statement was he took solace in Vermeer, which is a nice thing to say. I mean,
Yes.
it was that somehow Vermeer was in a very violent time, but somehow art helped him.
But I'm not sure that I was able to work out any way consciously of dealing with it, you know. But I was able to steel myself and to work dispassionately. By the way, I'm glad you mentioned Antonio Cassese. I consider him to be the father of modern international criminal law. He was a judge at the tribunal just when I went there. He left 1 year after. And then, of course, you know, he became president of the tribunal for the Lebanon. But he has done tremendous work in the area of international criminal law. But how I dealt with it, I'm not able to identify any particular method. I'm a lover of art too, and I'm a great lover, admirer of Vermeer's. Is it the lady with the
Pearl earring.
pearl earrings? Well, actually, is at a museum in the Hague, and I go there to see. I have I have a fair collection of paintings, and that brings a lot of comfort and solace to me, you know. But man's inhumanity to man was very evident in the work of the tribunal. You could not escape it. I'll give you 2 examples of what I consider the worst cases of that. In the last trial over which I presided, there was an incident in which about 100 Muslims were herded into a building, which was then locked up and set on fire, killing them all. But then, when I became president of the tribunal, then I had to preside over appeals from the Rwanda tribunal. And would you believe it, I came upon the very same incident in which Tutsis took refuge in a church. And the church was then bulldozed, knocked down, killing all of them. I believe those are the 2 worst experiences that I had to deal with of man's inhumanity to man in my work at the tribunal.
So there's so many things we could ask, but is there for judges of the tribunal, as you hear these things, is there an image of madness? Is there an image of how is it that maybe all of us are capable of such things? How does it happen that this comes about? Are these discussions, or is it in a way too hard for a community to move into those discussions?
I think many judges have that discussion among themselves. You know? But after a while, if you're not careful, you can almost become desensitized to it, and it is just routinized, you know, and it becomes almost quotidian as work that you do on a daily basis. And it is quite easy to forget that you're not just dealing with a name, but you're dealing with somebody who was a living human being with flesh and blood, and who suffered as a result of very serious breaches of the law. And you mentioned Nuremberg. Now, the great achievement of the tribunal where I worked is that, of course, it built on Nuremberg. Heads of state and important government officials were no longer able to hide behind the state, you know, individual criminal responsibility, which started with Nuremberg. We built on that in the tribunal, and we were able to try a very wide range of persons who were indicted, from sitting heads of state. Milosevic was the first sitting head of state to be tried. Generals, important civilians, and foot soldiers. So the spectrum was very wide, and that is really the great contribution that the tribunal has made to international relations. It has shown that there need be no impunity for people like that. That people like that, people like those, can be brought to trial and be tried fairly.
Are there questions concerning this period? Way in the back.
Yes.
Yeah.
Please stand up.
Yes, I will.
Thank you.
Lots of questions. So, one that occurs to me following that recent few words about the International Tribunal in Yugoslavia. The Nuremberg trials ended in the death penalty for the worst offenders, and you come from a country which still has that on statute book. Do you have a personal view about that?
The question,
Yes.
just for the record, the question relates to the penalties.
Yes. Well, at the tribunal, as you know, we don't have the death penalty. It's life imprisonment. It's quite true that in Jamaica, and in fact in most of the Caribbean, the death penalty is still applied. We have many hangovers from colonialism, and that's one of them. That act which still retains the death penalty is the Offenses Against the Person Act of 18, I'm forgetting it. I used to know these things by heart, but it's a 19th century act. Now, what has happened in Jamaica is that in the 1990s, we adopted a law which did not abolish the death penalty, but which differentiated between homicide that was culpable and homicide that was not culpable. So we now have a law in Jamaica in which, in very few cases, the death penalty can be applied, and in other areas, homicide, the death penalty is not applicable. In Jamaica, no one has been harmed since 1988. You know? So although the law is still on the statute book, you could have a very rich intellectual debate as to about its application. Now, you've asked about my own view on it. You know? Now, I started out as an abolitionist, you know? But when the law in Jamaica was applied, I thought it was a fair compromise to divide homicide into offenses that will attract it, the very, very serious offenses, treason and certain kinds of murder, and others that will not attract it. So that when you look at Jamaica, you have to bear in mind that the penalty, although on the statute books, has not been applied from 1988. That's almost de facto abolished. One reason for that is that same human rights bodies, persons who are convicted for murder would take their cases to either to the committee established under the ICCPR, the International Covenant on Civil and Political Rights, or to the Inter-American Commission. And those cases would drag out for years. In 1992, there was a case called Pratt and Morgan that went as far as Jamaica's highest court. And that's another matter. Jamaica's highest court, just slight diversion, whether you believe it or not, 53 years after independence remains a court that is called the United Kingdom Privy Council, located right here in London, 5,000 miles away from Jamaica. The manner in which I have expressed myself will tell you how I feel about that. But back to the question which
so how do you
asked.
cope?
Back to the question that you asked. In Pratt and Morgan, the Privy Council decided, it's a very landmark case, that anyone who had been on death row for more than 5 years should be should be set free. The Governor General would use the powers that he has, the prerogative that he has. So that has contributed to the death penalty not being carried out in Jamaica. But it's a very serious problem for countries like Jamaica. Jamaica has not had any altercation with any country. I'm very pleased to say we are an island state, but we have had more than our fair share of domestic violence. Violence is very strong, and the murder rate in Jamaica is exceedingly high. It's probably the highest in the world for a country which is not at civil war. So if you were to take a poll in Jamaica today on the question of the death penalty, you would probably have over 90% favoring its retention. So that when you talk about the death penalty, you have to take account of that as well. I don't find that it is useful to engage in talk at a very intellectual level, because what may be applicable in one set of countries may not be. I would really like to see Jamaica move to getting rid of the death penalty on our statute books. Not only the death penalty, the burglary law. Again, if you were to take a poll in Jamaica on that question of you'd find you'd find a vast majority would favor retaining that law. But we are moving in a direction where I think there is a softening of that position. I'm pleased to say. I think we are witnessing a slight change. Just before the last general elections, there was a debate between the leader of between the two contending leaders, you know? And they were asked that question in the debate. You know? And the leader who is now the Prime Minister, Portia Simpson Miller, she said that she would consider it, the question of removing the law, of a change. You know? The other contender said no. You know? But I think it is very significant that the person who is now the Prime Minister of Jamaica could have made a statement like that. Very significant that she saw the possibility of making a statement like that, which would not have gone down well with the vast majority of Jamaicans.
Thank you. I'll go here and then to the back.
Yes?
Dr. Hestermeyer.
It seems to me that one of the major ideas of international criminal justice is to build a record of the crimes that have been committed. And in the case of the Nuremberg tribunals, that record, along with American policies, broke through, if you want, the tribalism and the tendency of a country to say, well, we didn't commit it. And if you look at German education now, there's a constant owning up to the genocide. And in fact, when there's a statement by another head of state denying the Holocaust or denying German responsibility, the German state will issue a statement saying, no, we know our history, we're responsible for the Holocaust. It seems to me that the ICTY has built an enormous record. So the record is there, but it hasn't achieved, or it hasn't quite achieved breaking through the tribalism in the sense that you would still have Serbians tend to favor Serbs and emotionally defend Serbs, and Croatians emotionally defend Croatians, rather than owning up to the crimes committed. Would you agree with that statement?
I agree, yes.
If so, what is the problem, or
yes.
what? It's not necessarily a failure of the tribunal, but where is the failure and how can that be changed?
Well, I think it's a very important point that you have made, and it's quite correct. The tribunal has not succeeded in the way that you may say there was that kind of success after Nuremberg. But one thing to bear in mind, of course, is that we are now, 70 years after Nuremberg, and we are just, the tribunal is still functioning. So give it a little time. Give it a little time, but that is not in any way to detract from the legitimacy of the point that you make. You know? One of the things that I did when I was the president was to have a conference on the legacy of the tribunal. I had two conferences. The first one looked at the regional legacy, and the second one looked at the jurisprudential legacy. And the first one that we had, I think it was in 2010, I had all the stakeholders from the different countries there. And it was clear to me that the wounds were still very, very raw. The antagonism between various groups was very, very open, and you could see it. And there was a time in the conference when I had to take over because it was becoming, probably getting a little out of control, you know. And I had to say, I don't stop them from talking. let them talk. That was their experience. And talking about it is a kind of catharsis. And I thought it important that it's the victims, the victims wanted to talk about their experience, And I didn't think it was proper. It was appropriate to curtail them. So I made a little speech in which I commented on that and said, continue. But you're still right. You're still right. What you called tribalism, the divisions, the divisiveness, notwithstanding the best efforts, I think it's still there. It's still there. But the tribunal can only do so much, can only do so much. That is political work that has to be done at another level to bring about greater unity than there is now.
There's a question in the very back corner.
Sir, reference was made at the beginning of the conversation to your predecessor, one of your predecessors, Zafir Khan, who reminded of his recusal on an important case. I'm just wondering, I'm interested to hear from you, whether you had this situation where you recuse yourself from the national recusal situation.
Well, for the court, I've only been there at the International Court now since February, so I haven't had much experience. And if a situation arose in which I thought it was proper to recuse myself, of course I would do that. Yes, and some persons have to be recused as a matter of the statute. If you have appeared as a counsel or agent in a case that is before the court and you're a judge, you're obliged to recuse yourself. But recusal on other grounds, of course, I haven't had that experience yet. Still time to come. Yes.
So, Professor Tsoulis.
You talked about fairness. Some people say one norm of fairness is treat like cases alike. And there are critics of international criminal law who say that it's fundamentally compromised by its failure to take that norm of fairness seriously. That although there was the case of Yugoslavia, of trying European defendants, that on the whole, defendants are overwhelmingly from Africa. And how is it possible to take seriously a system of criminal punishment if it is overwhelmingly biased towards people from one particular region? Is the answer going to be, as was before, give it time?
That's a massive problem that the International Criminal Court faces, that the vast majority of its cases are from Africa. But you know as well as I, the standard answer that is given, which is that most of the cases from Africa were actually referred by the African states themselves to the court. Now, it still doesn't help the image, the perception of the International Criminal Court when you have a situation, no matter how it arose, no matter how you explain it, you have a situation in which 90% of your cases come from one particular continent, and a continent with the kind of history that it has.
So along that line, as president of the Criminal Tribunal for Yugoslavia, you would have seen the cost of that tribunal. You would have been reporting on the budget.
Yes.
And we are nearing a point now where it's nearing the end. It'll go into the transitional mechanism that's been designed. Rwanda's about to close down. And what will be left is the International Criminal Court with the occasional case. So is there a sense that we won't have another criminal tribunal for Yugoslavia? I mean, that type of conflict-specific, expensive tribunal in the near future? Or is it somehow going to happen within the criminal court?
Well, you know, it has been said that international criminal justice is slow and it is expensive. Yes, I was exposed to the administration. I had to become interested in the administration of the tribunal when I was the president, and had to wend my way to the United Nations on several occasions and appear before the ACABQ. That's the Committee on Budgetary Affairs, which, no matter what anybody else tells you, it is the most powerful committee in the entire United Nations. Because you can't get your work done at the organizations that you represent unless you can get by the ACABQ. You know? They are powerful. You know? So yes, the expense is there, and I don't think the UN will be quick to establish another international criminal tribunal on that ad hoc specific basis. I think the idea behind the establishment of the International Criminal Court is that countries would become parties to it, thereby not making it necessary to have these very expensive ad hoc courts. You know? Of course, we know that has happened. Many countries are parties to it. I think about 120, Professor? About 120 countries now. You have 193, but significantly, you know, there are very important powers that are not parties to it. You know? But certainly that was the idea behind the establishment of the International Criminal Court, to do away with the very expensive ad hoc tribunals. Mark, I'm very grateful to the Yugoslav tribunal for the experience that it gave me. You know? Yeah. But it's not the ideal way to go.
So we'll take one more question, and then I'm going to give him the closing words. Please. Please stand up. Thank you.
Can you? Yes.
I wanted to ask two personal questions.
Where are you from?
Trinidad.
Okay, great.
Is that a soccer comment?
Yes. No, he's a Trini. He's a Trini. He's one of us.
So the first question is, you were in Jamaica for a long time working, and then now you've moved into the international sphere and embraced the international career. And for a lot of people, that means essentially becoming, in a sense, stateless or homeless. You're in DC, and then you're in The Hague. And I just wondered whether in what ways that has impacted on you personally, and with professional repercussions. Second question is, as somebody, both as somebody of African descent and more so as somebody from the Caribbean, you're quite in a minority when you move into the international sphere. And I'm sure that was true of your experience at the Inter-American Commission, and then again at the international tribunals. And you can experience a difference, even if it's not discrimination, it's certainly difference. I'm just wondering in what ways you did experience that, you have experienced it, and how have you negotiated that difference?
Yes, thanks very much for the questions. The first one, let me deny at the outset that I'm stateless. I am Jamaican, and I have Jamaica in my DNA. I could never be from a country like Jamaica and be stateless. I go back to Jamaica whenever it is possible. If I have 5-6 days free, I go to Jamaica and come back. I have retained significant connections with Jamaica. On Tuesday of next week, I go to Jamaica to give a lecture on the 150th anniversary of the Morant Bay Rebellion. Do you know about that rebellion? Yes. Okay, the Morant Bay Rebellion, very important historic experience in the Empire, British Empire. I am chancellor of a new university there. I'm involved in sports. I've written a book on Jamaican athletics as a model for the world.
2009.
2009. Yes. And I've just produced a documentary called Just Run, which seeks to explain the system underpinning Jamaica's success in global athletics. Trinidad is not far behind. So I have always considered it very important to retain connections with my country. And I always see myself as a Jamaican. I'm first a Jamaican. I am second Patrick Robinson. But my nationality is the most important, most significant thing to me for many, many reasons. We don't have the time to go into that now. The second question that you asked.
Can I just add on
Yes.
that one?
Yes.
So I was in a meeting with Patrick recently, 15 people in the room, someone serving coffee. But it was Blue Mountain coffee that Patrick had brought for the meeting. And it was very clear,
Yes.
it was not about Jamaica does not belong here.
Yes.
It was about Jamaica has something special to bring to the room.
Yes.
And it was very palpable.
Yes, I have developed now this practice of taking Blue Mountain coffee for my colleagues at the court, you know, and they enjoy it very much. Some people have two, three cups. The only problem I have is that Blue Mountain coffee is the most expensive coffee in the world. And I would need a special subvention from the court to be able to offer it. But yes, the dean is right. If you ask me what is pride, pride is what I feel when I see see the response of my colleagues to Blue Mountain coffee, which is the best in the world, entire world. So yes, the other question, what was it, the second question? Oh yes. Of course it's inevitable. You're moving from a country like Jamaica with our experience, the history that we have had, the kind of exposure that I've had would have been something rare and exceptional. And so when I have moved to these places, it's a new experience, but I believe the foundations that I've had have helped me. And yes, sometimes there are difficulties that you experience, you know. But there are ways to overcome them. And I'm happy to have been something of a trailblazer for the Caribbean. In fact, as you know, there was one Caribbean judge before me, Mohammed Shahabuddin from Guyana. And when I went on the Inter-American Commission, I was, I think, the second Caribbean person. There was a Barbadian. So it was the two of us as common law countries. I can't say against, but We had to work to ensure that the common law was properly represented in all the drafts that we did. You know?
Patrick, you brought us a wonderful life. You shared just a wonderful life with us, and we're very thankful. Please join me in thanking His Excellency Judge Patrick Robinson for this wonderful life. So I'd like to present Judge Robinson with a photo. It's one that, in fact, our photographer tonight Dolly took. This photo is of the Old Bailey, and it could not be more appropriate for someone who started in prosecutions in criminal law.
Yes.
And we will be having a reception just down the hall. I'm sure you have questions for Judge Robinson. Thank you again.
May I just say thank you so much, Dean. Thank you so much, David. I have thoroughly enjoyed being with you. Just being among university students, you know, the atmosphere is so special. University students and members of the faculty, and of course my family and friends here. It has been tremendously wonderful, I would say almost a therapeutic experience for me. My first time back at King's. Again, I want to congratulate you on the wonderful building that you have, and that must of course inspire you to do very well in your work, whether it's international law or any other area of law, and in life in general. So thank you very much. Yes.
Yeah.